Chairman Wheeler, I have a couple of questions about the scope of FCC's regulatory authority. If you could answer yes or no, if possible, on this. Does the FCC have the authority to enact these proposed privacy rules under Section 706 of the 1996 Act?
We're asserting these rules under Title II. Section 706 is something we've asked questions about in the proceeding itself, but this is a Title II proceeding.
Not asserting under 706 at all?
We're asking questions about it. 706 clearly has a bearing on this, but we're doing this under Section 222 of Title II.
Does Section 706 of the 96 Act provide the FCC with authority to impose these privacy rules on edge providers?
We have said repeatedly that we do not believe or intend to assert jurisdiction over edge providers.
Commissioner Pai, based on your understanding of the position as it relates to 706, do you agree?
Senator, I do not. I think that while the intention of the agency might be not to apply the regulations at this time to edge providers, the virtual cycle theory that the FCC relied upon both in February 2015 and in the current notice of proposed rulemaking is certainly elastic enough to encompass edge providers within the scope of any privacy regulations.
Right. Thank you. Chairman Wheeler, Commissioner Pai, in his testimony, stated that you testified before Congress that because consumers deserve a, quote, uniform expectation of privacy, that the FCC would not be regulating edge providers differently than ISPs. Is this new rule, is this proposed rule consistent with that statement?
So as Commissioner Pai reported, I said that we will not be regulating edge providers. The expression different from the network is an issue that we are today, that what is being sought to be done today is to change the nature of the role of the network to be one that is similar to an edge provider. And that's where we draw the line, that American consumers have for decades expected that, because of an FCC rule, that the information that they give to the network is their information, not the network's information. And that ought to continue in this environment as well. And no, we do not intend to regulate the edge. And I find myself in a fascinating position with my colleague here that he's now the expansive interpreter of the statute, and I'm the conservative interpreter of the statute. We do not intend to regulate the edge.
Commissioner Pai, do you have any thoughts on that?
Well, certainly about the characterization, which I don't share, but more seriously to the question, I think the Chairman's exchange last November was very telling, because the question was, don't consumers have a uniform expectation of privacy no matter what they're doing or no matter who they're dealing with in the online ecosystem? The answer there, and I agree with the Chairman at the time, was yes, and that's why the FCC would not adopt a different approach. But the FCC's approach in March of this year was dramatically different, singling out ISPs for unique and intrusive privacy regulations. I think is both obviously a betrayal of that commitment, but more fundamentally, it doesn't recognize what the White House recognized in the 2012 privacy report when it said that it was critical for privacy regulation to be technologically neutral and to reflect a consistent set of consumer expectations.
If I take my phone into my home, say I've flown home to Arizona, which I do frequently, and I turn it on airplane mode or turn the wireless off, and I get home and forget to turn wireless back on, or an hour later, I turn the wireless on, so I'm covered by broadband part of the time and an edge provider or cellular service the other. Am I regulated differently depending on when I turn my wireless on or off? Commissioner Pai.
Well, Senator, certainly the access to information that both ISPs and edge providers would have would vary dramatically For example, if you took your smartphone home and you logged onto your Wi-Fi network, if you then took it on the road and were connected to a cell tower on the way to the Senate, if here in the Senate you connected to the Senate's Wi-Fi network, and if you decided to go to a coffee shop and log on to their Wi-Fi network, you might have the same device, but be using multiple different ISPs across multiple different platforms. The one entity that would have consistent access to all your information would be your edge provider. For example, for an Android smartphone, I can't see from here, but it would be Google in that case. And that's part of the reason why I've argued, and that why President Obama's counsel, Peter Swire, in his privacy report argued that ISPs have a small and diminishing access to the information that consumers have when they go online.
Let me answer your question specifically, because you deserve an answer. One, when you turn your phone on to be a phone, it is under the telephone aspects of Section 222 of the Communications Act. And you have privacy rights and expectations. The question is, why is it that the same device in your hand, when you then say, okay, I'm going to go to the internet, nope, sorry, all that information doesn't belong to you anymore, it belongs to the network. That's the point that we're getting at here. So as you are spot on. When you have a device, one function you have privacy protection, the other function you do not. And all we're saying is that there needs to be equivalency between those two.
Thank you. I'll follow up on this in my questions later. Chairwoman Ramirez, had these regulations that the FCC has proposed been in effect during the past couple of decades that the FTC has been regulating privacy, would we see the innovation that we've seen in the internet if these more stringent prescriptive rules had been in place?
Chairman Flake, I'm afraid that it's difficult to answer that question. I know that we're in the process of evaluating the proposed rule that the FCC is considering. What I can tell you is the way that we have sought to balance innovation and consumer protection. And while there are still questions that we are looking at as to whether ISPs ought to be treated differently in this particular instance than other companies in the ecosystem, the framework that we have applied is one that focuses on the nature of the information that's being collected and used, and in particular the sensitivity of that information, and also looking at consumer expectations.
Commissioner Pai.
Senator, can I? Oh, if you're working out, I just want to.
Sure, you bet. After Commissioner Pai.
Senator, we can't say for sure, but I think it's a fair statement to argue that the internet economy that we have, that's the envy of the world, is due in part to the fact that the FTC applied a uniform framework, a very flexible case-by-case approach that allowed entrepreneurs across the ecosystem to experiment, consistent with consumer preferences. And I think that's part of the reason why, as Chairwoman Ramirez pointed out in a very perceptive speech last November, that there are things like cross-device tracking that can supply some benefits to consumers. If you're looking for shoes on your home computer and then you get a discount on your smartphone, or if you were watching a show on your TV and then you transition to your mobile device, those are the kinds of things that I think have been very healthy for the internet economy. And there's no telling how much poorer consumers would be if we had artificially restricted the use of that kind of cross-device information.
Thank you. Chairman Wheeler.
Thank you, Mr. Chairman. The internet began on a common carrier basis. The internet began, the first DARPA trials, as well as the early internet itself, was all on telephone networks using dial-up modems. And those activities were subject to the FCC's privacy protection rules. At the very same time, the internet went like this.
Yeah, Commissioner Pai.
Senator, if I could just point out, the early dawn of the commercial internet, it was not exactly the time we think of as the most robust in terms of entrepreneurship and innovation. That explosion has come with the 2 decades of experience with the FTC at the helm. Secondly, it's important to remember that some of the people who really pioneered internet access, broadband adoption, and the like were not regulated as common carriers. AOL, for example. I know now it seems hard to remember the days of the CD-ROMs being sent to our homes, but that was the gateway to the internet for millions of people. And that was an unregulated, under entitled to the service.
But it was over, AOL was delivering over the dial-up internet. And if the question, I think I understood the question to say, would the kind of regulation that we are proposing, if it had been proposed imposed in the early days of the internet, would we have had the growth? And I'm saying to you that AOL and all of these other services that, as Commissioner Pai has just said, were the beginning of the internet and the takeoff of the internet, all happened on a common carrier network that had privacy expectations.
Well, my concern would be that I certainly, I assume that AOL, the old service I used to have, that we could very well see the growth, the slow growth, under this kind of regime. I'm just wondering if we would see the growth that we've seen in the past couple of years and expect to see over the next several years with more innovation possible. Commissioner Oldhazen, the FTC, as you mentioned, has a long history of dealing with privacy issues. You went through a lot of process to build these regulations to determine how you would regulate. A series of workshops, privacy experts were called in, advocates, industry stakeholders, then issued a draft staff report, took comments before adopting a final report. This was all in the report in 2012. The FCC, on the other hand, held one workshop a year ago, and then a year later issued this complex PRM with 500 questions, tentative conclusions, and proposed rules. Has the FCC gone through the deliberative process, in your view, that the FTC did in terms of determining how to regulate?
Well, you've mentioned the process that the FTC has undertaken, and it really has been a long-time iterative process. Actually, our first online privacy workshop was held in 1996. So I think that our approach, which has been incremental and technology neutral, and as Chairwoman Ramirez said, looked at the type of information and consumer expectations, has allowed us to develop our approach in a way that gives us the benefit of flexibility and the understanding as consumer expectations and technology has changed. The FCC approach, obviously, this is a follow-on to the reclassification that was undertaken in the Open Internet Order. So it has been a much more abbreviated process, in my understanding.
Right. Chairwoman Ramirez, in your view, has the FTC's privacy protection regime over the years been sufficient to effectively protect consumers' rights as it relates to ISPs?
Chairman, I think the Federal Trade Commission has done a very effective job in addressing consumer privacy and ensuring that consumer information is appropriately safeguarded. And I have mentioned at length a number of initiatives and the enforcement work that we've done in this area, as has Commissioner Oldhazen. At the same time, I do think that there are certain areas where we could use additional authority. One example is that the Commission has, on a unanimous basis, called for Congress to enact data security legislation because we believe that more needs to be done in that area and that we could use additional tools to address the protection of consumer information. So that's just one example. But I do believe that we have been an effective agency when it comes to privacy.
Okay. Commissioner Oldhazen, do you have anything to add there?
No, I agree completely with the Chairwoman.
All right, thank you. Commissioner Pai, what kind of information do ISPs actually see, and how does this continue to change, or does it change?
That's a good question, Mr. Chairman. It has changed over time. So currently, for example, 70% and going up of all internet traffic is encrypted. So for example, if you go on your laptop and you access your Gmail account, you'll see HTTPS. Well, the S part there is critical. That means that the ISP can only see that you're accessing Google, accessing Gmail. If you do a Google search, the ISP can only see if it's encrypted that you're accessing Google and the domain of the site you link on. They can't see what search you put in, they can't see what site, what particular product you're looking at, and so forth. And that's part of the reason why Peter Swire, the president's former economic policy and President Clinton's former privacy counsel, has said that ISPs have a very limited amount of information from consumers. And that assumes, of course, we're talking about just one device. Currently, the median number of internet-connected devices in the home is something like 6. It's going to go up to 11 by 2019. And so when we're talking about multiple devices across multiple networks in multiple locations, ISPs have just a smidgen by comparison to some of the other players in the online ecosystem. And that's part of the reason why the online advertising market sees ISPs as a relatively new and minor competitor compared to some of the dominant players who have the lion's share of the revenue.
Thank you.
It's quite a smidgen. If you go back to what I said in my statement, let me just read what one company says. A combination of information from wireless and Wi-Fi. We can tell where you're sitting in a room from your Wi-Fi connection. Wi-Fi locations, TV viewing, calling and texting records, website browsing, and mobile application use. Every mobile application you use, every website you go to. And I respectfully disagree with Commissioner Pai on the assertion that somehow encryption is going to solve everything. First of all, there are about 85% of the top 50 websites that are not encrypted. But even if they were encrypted, you go to the example that Senator Franken gave in his opening statement, going to WebMD. And then you go to the next level down in WebMD, which is information about this cancer or that cancer. You may not be able to see what is coming out about this cancer, but you know that you have gone to WebMD/prostate cancer or whatever. And then you know that you have gone to all the other URLs, www.prostatecancer.net, whatever the case may be, and you are able from that to put together a collection of knowledge about the individual which should not be sold by the network. The network is just taking you to get that information. They don't have the right to turn around and say, hey, I've got information on who's got cancer. That's wrong. They can't do it today with a phone call. They shouldn't be able to do it on the internet.
Senator, if I could just briefly respond, I'm pleased that the chairman has not disputed my assertion that there's upward of 70% of all internet traffic which is encrypted. Obviously, that reflects the bulk of consumers' use of the internet. Secondly, it's important to remember that the multiple contacts and multiple devices matter significantly. The example I gave earlier about your smartphone, for example. Your ISP only has insight into your connection at home in that example. Google has knowledge about all that information across all of the different platforms. Indeed, given the fact that Google encrypts the majority of its traffic from Gmail to regular Google searches, Google knows exactly what kind of cancer you're looking at, what providers you might have looked at, how worried you are based on your search queries. All your ISP knows is that you accessed Google and the particular domain name, not the entire URL, just the domain host. Prostatecancer.net in this example, whereas the edge provider knows all of the various pages you looked at and can tailor its advertising accordingly. Significantly as well, I'm pleased the chairman has not disputed the fact that the edge providers are the ones who are the dominant players in the relevant market here, which is online advertising. That's a very significant fact, and that's why former Chairman Leibowitz has said it's odd to single out ISPs when they're the new competitors in this space.
Here's the interesting thing, that when I go to Google to find prostatecancer.net, that is a decision that I am making. It is my choice. I don't have that kind of choice on the information that I give my network. It's going to take that information regardless. And the network has the right to look at every piece of information. I go to WebMD, and WebMD collects information on me. I go to weather.com, and weather.com collects information on me. I go to Facebook, and Facebook collects information on me. But only one entity collects all of that information that I'm going to all those different sites and can turn around and monetize it. And like I say, we're in favor of them being able to monetize it. They just need to be able to ask the permission of the people whose information it is. The fact that I hire the network to take me to prostatecancer.net does not give them the right to my information.
One last question, if you indulge me before I turn back to you, Senator Franken. Various stakeholders have requested that the FCC extend the comment period here. But on April 29th, the chief of the FCC Wireline Bureau denied these requests in large part because, quote, granting an extension is not the norm, unquote. Given that it took the FCC over a year to notice the proposed rules and the total NPRM is close to 150 pages long, and it asked more than 500 questions of the stakeholders, do you think that extending the notice and comment period would be appropriate and a fair thing to do, Chairman Wheeler?
Golly, you know, we've been discussing this issue for half a dozen years. Commissioner Pai in his objection to the open internet order kept talking, let's talk about privacy. Let's talk about what the impact on privacy is. Everybody's been talking about privacy. When the ISPs appealed our decision and went to the court and asked for a stay, they specifically said in their stay, we need you to stay this because we need there to be certainty on privacy. Well, the court said, no, you don't get the stay. We're now providing certainty on privacy like they've asked for. So, I mean, I think this has been an ongoing process. It is a filling up record, and that there will be a voluminous record on this.
Chairman Pai,
Thank you for the promotion. Mr. Chairman, I think there are a couple of different responses. First here, as you pointed out in your question, the FCC opened up this can of worms in February of 2015, then took over a year to finally issue the NPRM. I don't think it's too much to ask for a couple extra weeks to allow the numerous stakeholders, some of which are trade associations with hundreds of members who have to be canvassed, to weigh in on these many, many questions. I think Commissioner Rosenworcel, our colleague, got it exactly right, that there are some contradictions here that make privacy complicated, and this rulemaking asks questions, lots and lots of questions. It's extremely important for the FCC to act, if indeed it's going to have a full and impartial rulemaking, to act on the basis of a fully developed record. And we can't do that if we don't give people enough time to comment. The second point, I would argue, is in addition to when the chairman is saying, well, you know, ISPs everybody knew that this was coming. Well, yes, we knew that the door had been opened, but we didn't know exactly how the FCC was going to walk through it. And I think a lot of people, ISPs in particular, were probably misled, and they relied to their detriment on the chairman's commitment last November that we will not be regulating ISPs any differently from edge providers. Assuming they had gone ahead with that assumption that it's going to be an FTC-like framework, they would have been shocked when they saw the FCC's 500 questions proposing very prescriptive, very pervasive, and very selective regulation.
Thank you.